Good morning, everyone. Welcome to the Technology Transfer Primer. Today, we are honored to have Dr. Yahong Ling, the Associate Director of Hong Kong UTTO, Associate Professor of Faculty of Law, Hong Kong U, to share us the patent inventorship and ownership for the university inventions. And then we have Mr. Mark Paulson from US, the manager of Paulson IP Consulting, and Ms. Chiang Ling, partner from Zhong State, to share with us the global patent strategies, related issues, and risks. We apologize that we need to amend a bit today's rundown as Dr. He is currently managing some emergency issue, so he's not able to share with us the importance of IP protection of universities' inventions. We are checking his schedule and hopefully we can hold another webinar later. So shall we start with Dr. Lee first? After all the speakers finish the sharing, there will be a 20-minute Q&A session. Please feel free to raise out your questions in the chat box later in the Q&A section. Okay. So Dr. Lee, you can start when you are ready.
Okay. I'm not, I can't start my video. Okay. Yeah, good morning, ladies and gentlemen. And I'm very happy to share with you about the patent inventorship and the ownership for university research today. Unfortunately, Dr. He cannot join us today because of the accident. And I believe if he's here, he's going to talk about how important to file patent and to have a patent protection for your research. Yeah, if there's no patent, you basically you cannot protect your invention and you cannot exploit your invention. And among the patent rights, the ownership, the right to the ownership is very important because ownership in patent law, can control and exploit the patented invention and can assign, license, or mortgage the patent, and also can sue infringement of patents. And ownership is also closely related to inventorship because the chain of ownership starts with the inventorship. Inventor is presumed to be the first owner of the patent, although there's some exceptions to this. So what I'm going to discuss today is the inventorship and ownership, what they are, and also the employee or service inventions and joint ownership, and the importance of claiming priority, and lastly, resolution for patent inventorship and ownership disputes. First of all, let's look at what is an inventor. Basically, in patent law, the inventor is a human being, it's a natural person. Therefore, entity or like organization, companies, or a robot or AI machine cannot be an inventor. So in the patent application, you cannot put the organization or the institution as the inventor. And also you cannot put the name of the AI machine in the inventor, as the inventor. For example, there's a case about Dabus, that is the AI machine, and his owner put the Dabus, the AI machine's name in his application. But eventually, European Patent Office and also UK Patent Office rejected the application because they said that the inventor can only be the human being, and to be able to exercise property and personal rights, that the inventor must be legal personality, which AI system, AI machine do not have. Okay, and secondly, inventor have to be actual devisor according to the actual devisor of the invention according to UK patent law. And according to Chinese patent law, the inventor have to be any person who makes inventive contribution to the substantive feature of an invention. And therefore, the following person are not inventor, are the person who is responsible only for organizational work, and the person who provides, facilitate for making use of material and technical means, and the person take part in other ancillary function. So if you are the organizer but never participate in the invention, you cannot claim to be an inventor. So the same as the person who provides the material, equipment, funding. So to be an inventive contribution, the contribution has to be concrete and specific, not vague in general. So the inventive contribution include the contribution to the inventive concept and to solve a problem or answer a particular question, to perfect or improve some existing device or process, to generate the idea or avenue for research. And also to be something that if other would not have the idea without that person's input. And so the the contribution that merely merely provide an unnecessary detail that is not essential to the invention, and or the providing the material support, for example, like managerial or entrepreneur contribution, or the supply of a crucial starting material are not considered as the inventive contribution. The starting material, crucial starting material like a cell line and bioprospecting are not considered as the inventive contribution. Inventive contribution have to be someone who contributed to the inventive concept or who have participated in invention process. Inventor have the right to be mentioned as an inventor in the any published patent application or any patent granted for the invention. And here on the left, you can see that the inventor, there is a list of the inventor, and also there is a list, the assignee. Assignee means the applicant. So inventor and applicants could be the same persons, or also could be different people, like you know, the assignees are those the applicant, the inventors are the people who actually participated in invention. And so the question is that A invented a new method, and Y, X invented a new method, Y provided the funding but not participant in invention, then basically Y cannot be mentioned in the patent. And hello? And the next question is who can apply for and obtain a patent? And this really depends on, I'm sorry, someone calling me. Hello? Who can apply for and obtain patent? And it could be inventor, and also it could be someone else, like other patent applicants. And so it all depends on where you are and where the patent is filed and dispute arise, which means that the national law will control who can be the patent applicant or the patentee. For example, in the United States, the rights in an invention belong to the inventor. And in China, the right to apply for a patent belong to the inventor. But after the patent application is approved, then the inventor should be the patentee. And in Hong Kong, the right to patent belong to the inventor, and the right to apply belong to the person named as the applicant or his successor, or the person who is entitled to the property in the invention. And so the right to apply and the right to the patent also can be different from the inventorship. And UK, under UK law, any person can make an application, and the patent can be granted to the inventor or joint inventor, or to any person or person entitled to the whole of the property, or to the successor or successor in title. And the person who makes the application can be considered the patentee. Yeah, so you can see that inventor is basically to be presumed as the first owner, but the inventor can assign his right to other people. And the right is divided into right to apply for the patent and right to be granted the patent. And these two rights could be assigned to other people. So the inventor may not be the patent applicant or the patentee. And so like under US law and also Chinese law, this right for patent, right to apply for patent and the patent or other interest can be assigned. And under both countries' law, the assignment should be in writing and also to be signed and registered. So this assignment can often happen in the university or in the employment situation. And here now we going to look at the employee invention. And the employee invention in UK involved the two situations. One is the invention was made in the course of the employee's normal or specifically assigned duty, or that reasonably have been expected to have resulted from the carrying out his duty. And the second situation is that this employee have the special obligation to further the employer's interest. For example, this person is the senior managerial staff. And in China, there's also two situations involve the employee invention. In China, it's called the service invention. And one situation is that the invention made by a person in execution of the task of the entity. Another is the invention was made by employee, mainly by using the material and technical means of the entity. And the person can be the temporary staff member. And material and technical means of the entity include the entity's money, equipment, spare parts, raw material, or technical material. So those inventions are considered as the employee or service invention. And but the next issue is who owns the employee's invention. And different countries have a different law. For example, under US law, that is the employee own the service or employee invention. If the employer want to own the invention, the employee have to expressly grant his right in an invention to his employer. Otherwise, the invention belongs to employee, not employer. And under Hong Kong patent law, the employer owns the employee invention. And also under Chinese law, also it's the employer, the entity owns the employee invention. But under the second situation, when employee use the material and technical means of the entity, then if there's a contract between the parties, between the employer and the employee, and then the contract will apply. If the employee uses the material but doing invention without which is not belong to his normal duties, and then he can make a contract with the employer to allow him to own that invention. And another situation is the joint ownership. The joint ownership, basically the right to apply patent and the right to own patents belong to the individual or entity who made the invention jointly. And then the exercise of the right, including the right in application of the patent and right in patent. Under Chinese law, all co-owners have to be agreed. They have consent. They have to consent to, the exercise of the right. If there's the agreement among them, the agreement will apply. If there's no agreement, then any co-owner can independently exercise the right or license the right to other parties through non-exclusive license, and also the license fee obtained from the license should be distributed among the co-owner. But under US law, the situation is different. In the US law, the exercise, if there's no agreement about the exercise of the right, then each joint owner may exploit the patent without the consent of, and also without accounting to other co-owners. Okay, and if there's any dispute about who is the inventor and who should own the patent application right or the patent right, and then under UK and Hong Kong law, you can make the request to change that to the patent office. But under Chinese law, then that should be mediated by the patent office, and or maybe subject to the litigation at the court. Then after the patent is granted, and then the dispute usually is resolved at the court. And there's an example. There's a case about the university ownership of the invention being disputed, like between Stanford and Rothschild. And this case involved researchers and employed by the Stanford and signed the employment agreement with the Stanford. And the agreement says that any invention of the researchers the researchers agreed to assign his right to Stanford, but later he signed another agreement with a company, Cetus, in order to get the access to the company, and the agreement is to will assign and do hereby assign his right to the company. And then later on, the Stanford patent his invention for the diagnostic test of HIV infection. And the company, the Rocher, acquired Citus and commercialized the invention. And then Stanford sued patent infringement. But Rocher claimed that they have a co-ownership because they claimed that the researchers had assigned his right. But eventually the court decided that the Stanford agreement was a mere promise to assign, but the Citus agreement actually assigns the rights. Therefore, Stanford does not own the patent. And so you can see the difference in the term of the assignment. One is agreed to assign, another is will assign, and hereby assign. So agreed to assign basically means that it's a promise to assign the right in future. And assign means it's already assigned. So after this case, Stanford changed its policy on inventorship and ownership, and changed the term from shall assign, will assign, agrees to assign to is assigned to the university. So this means that any employee, when they signed the employment agreement, and he already assigned his right to the university. It's not will assign and shall assign in the future. Okay, so comparing with the Hong Kong U's IP policy, Hong Kong U still use the term shall assign the right of employee's right to the university. So maybe this is something to consider whether this should be changed in the future. And also under Hong Kong U's IPR policy, the staff shall not enter into any agreement with the third party, similar to Stanford's situation. When you enter the agreement with the third party, you should basically be aware this is this is not the university policy, complied with the university policy, and should at least let the university knows you are entering any agreement with the third party. And also Hong Kong U's policy about the fragmented IP ownership, and anyone who come to the university from another university, and you need to basically immediately contact with the Hong Kong U to clear any ownership problem. Yeah, so this is something to be aware, particularly for the university, because the staff sometimes change their job from one university to another university, and they started the same invention from the previous university and continue the invention into the new university, and then there's a ownership problem involved, and then that has to be clarified. And another issue is to how to claim priority in ownership. And my suggestion is to file US provisional patent as soon as possible, and also file the PCT application, and also include all applicants, especially the one in the first provisional applications in all subsequent application. I put this here because there's a new case that's still ongoing, involved the most recent, the Nobel Prize winning technology, that is the gene editing technology. And many people may not aware that this gene patent, the gene technology have the patent, and also have involved the patent dispute between two institutions. And the Nobel Prize winner, Professor Carpenter and Doudna, they are considered as the Berkeley team. And they basically they invented the CRISPR-Cas9 gene editing tool. And they published the paper. Actually, there's two teams. Another team is the Broad Institute in affiliation with MIT and Harvard. And these two teams were competing in filing the publishing paper and filing the patent. And basically the Berkeley team published a paper and also filed the patent earlier than Broad Institute. And but they got the patent later, and their paper and the patent did not mention eukaryotic cell. My understanding that the eukaryotic cell is more advanced than the prokaryotic cell. So eventually there's a patent dispute because the Berkeley filed the patent earlier, but the Broad got the patent earlier because they filed the fast track proceeding. So the both parties claimed the patent right over eukaryotic the eukaryotic test tool. And then the USPTO and decided that both parties enjoyed the patent rights for different parts, but then Berkeley appealed the decision to the Court of Appeal for the Federal Circuit. And then the Federal Circuit basically decided in favor of the Broad Institute, because they said the Broad Institute have a specific claim to the eukaryotic cells, and while the Berkeley team claim was too general. And then eventually the USPTO patent trial and appeal board decided again the Broad had a priority, but the Berkeley also enjoyed the right in some critical component of the invention. And in Europe, the Broad application, the invention patent was revoked for the different purpose on the different ground. Because the Broad filed several provisional application in the United States, and then claimed the priority, the U.S. provisional application at the priority to cover the subsequent filing. But they had made one mistake, that is they didn't include the inventor, Professor Luciana Marafini, the name in the subsequent application. The Professor Luciana Marafini was mentioned as the first provisional application, but not included in the subsequent application. Then, according to the European law, to validate the claim priority from an early application, all applicants named on the early application must be named as the applicants on the subsequent application. Because of this omission, this mistake, the Broad European patent was revoked. So in summary, there's certain things we need to pay attention. One is that the inventor is the one who makes the concrete, the specific inventive contribution. And the inventors have the right to apply and own patent by default. But the inventor can assign his or her right to others. But the assignment have to be in writing and have to be presently assigned, not shall or will or agreed to assign. And the agreement have to be signed and registered. And for employee invention, the different countries have different rules. In the United States, the inventor have to be the inventor or employee. It's own the patent unless expressly assigned to the employer. And the UK laws and the invention belong to the employer under the two circumstances. And China also to the employer unless agreed to the contrary in case of use of material. So under Hong Kong use policy, it belongs to the university, but must be assigned in writing, not only by the employment agreement contract, but also you have to sign different assignment agreement. Joint ownership, it usually follows the agreement and also have to be consent for exploitation in China by all the co-owners. If there's no agreement, then the different law have a different, different rules on this. And also lastly, it's very important to claim priority by filing quickly with all applicants' name included. Thank you very much, and I think my time is up, and I will pass this to Chiang and Mark.
All right. Good morning, everybody. Chiang and I used to be partners at Jones Day, and I'm a patent attorney in the U.S. who have practiced probably about 30 years and have semi-retired at this point, although I still do a lot of work for a few clients, and a lot of them are startups. And this presentation is going to go through some of the things that you should think about when you're deciding what you're going to do with exploiting a particular invention. And it's not going to be very much on the law. It's just going to be pretty much just practical stuff that you need to think about. Discoveries often get away from people, and that's due to a lot of reasons. It can be poor patent strategy. It can be not thinking something is patentable. There's all kinds of stories. There's a very famous story that came out of Stanford University, and that was the original DNA patent that was developed by a professor there, and he was about to give a talk on it, and the dean or somebody found out about that and went over to the gentleman's house at night. And he says, why aren't you filing a patent application before you give a talk on it? And the scientist said, there's nothing patentable here. Well, they convinced him to withdraw from the talk, and they filed the patent. And I think Stanford got something around $200 to $250 million from licensees out of that. So what I'm telling you is, if what people think is patentable is usually closer to a ceiling, what is actually patentable is usually much closer to the floor. I mean, so you shouldn't be deciding those things. You should go ask somebody that knows what they're talking about. The thing I tell inventors is this. I ask them, is it new? Do they think it's new? Have they ever seen it before? And if they say yes to that, then I say, well, do you care if others use it? If you do, then just publish it, because you don't need the patent if you don't care what others do with it. Do you want to make money out of it? Well, then you want to patent it. and ideally, can you keep it a trade secret? That's the best. I would much rather have somebody keep it a trade secret. Unfortunately, most things cannot be kept a trade secret. I have a client in Australia, in Canberra, that does mapping for wind farms. And the algorithms they use sit on one computer, and there's only a few people who have access to it, and they're very complex algorithms. And they made a decision, which I still agree with, to keep it a trade secret. And that company's gone public and is doing just fine. But most things can't be kept a trade secret, which then takes you, do I file a patent and where? Protecting IP is tough stuff. It really is. It's a very complex field with lots of pitfalls in it. So planning and talking to people is probably the most important idea. Money for startups, money and allocation of research is often a huge issue. Unfortunately, too many patents get filed, but they get poorly protected. In that CRISPR case is a good example. You can imagine the amount of money that has been spent on lawyers litigating those CRISPR cases. My guess would be if somebody hadn't published that paper, it wouldn't have spurred the other ones on to file the patent. So there is a rule. You really should keep your inventive ideas completely secret until you filed the patent. And the only people you should talk to before you file the patent are for sure people who are under non-disclosure agreements. That's pretty important, because if it becomes public knowledge, or it gets published, or it gets used in public, that can have a severe effect in many countries on your patent rights. So my ideal is I don't tell anybody about the patent even after it's filed until it publishes, who is not under a confidentiality obligation. Another thing is it's really hard to evaluate what I have. Is it worth patenting? And that's a very complex question. I mean, it depends on what you want to do with it. It depends if you want to make money off of it, license it, sell it. But you really should do all that discussion before you go and file a patent. Another thing that's not on here that you really should do, and it's easy to do, you should do prior art searches, looking for what's in the literature. And Google Patents is great. The European Patent Office has a wonderful site. You can find a lot out and save yourself a lot of fuss if you spend 4, 5, 6 hours doing prior art, looking for stuff that is similar to what you have. You can also often use those patents, especially, to, in essence, lift text or lift ideas as to how to position your invention. The one caveat I would warn you is, I've had it happen many, many times. Inventors or startups I'm working with find a patent and they think it's a real roadblock. It's a big piece of prior art for them, and it's not. It's not a piece of prior art. I had a client in Australia that spent a huge amount of money with a firm because they thought they had a publication that was a huge roadblock for them coming forward. So I got involved with it through a venture capitalist I knew down there. And we looked at the publication. I thought, it's not that bad. But then it was odd because it had been published on the internet, and but at a later date, but according to the internet, it was in a journal that had been published, several years earlier. So I pestered the client into getting on the phone with the library in Melbourne. And I said, ask them to go pick up the journal and see if it's actually there. And they thought I was crazy about it. We went, they picked up the journal, it wasn't there. The article hadn't been published on the date that the internet said it had been published, which made it not prior art. But we still put it into the US Patent Office, and it never really caused any problems. So sometimes you have to be a little bit of a detective when you're tracking these things. But I would encourage you to look at the art and it will give you a sense of it. But I would also encourage you to not be overwhelmed by the art and think that it destroys what you're trying to protect. Commercialization, especially for a university, is probably the biggest thing. And the more you can get the commercialization people at the university to talk to you and to plan with you how this is going to be handled. Because why file it if you're not going to license it or sell it or commercialize it in some sense? To me, it doesn't make much sense to spend the money that's required, because patents are expensive, especially ones that you file in 5, 10 countries around the world. So your commercialization people, if they're good, can be your best friends, and you should, and I would encourage you to pester them as much as possible to try to get stuff so you get a real understanding of this stuff. Okay, before you file a patent application, you really have to plan where you want to file it. And I know that you may not know, but you have to make your best guess. The reality is a big chunk of the value of patents in the United States, a reasonable chunk of it is in Europe, a reasonable chunk of it is in China, Japan. And, you know, in general terms, the rest of the world has limited value, but typically people want to file, I would say, in anything from 5 to 10 different countries or jurisdictions. How you write the patent specification with your patent attorney is directly influenced by where you want to file it. Now, most people don't get that, so I'll repeat it. How I write a patent for a client, I want to know what they want to do with it, because if they're going to license it or sell it, how valuable the product is behind it, and so forth. How you gather that information tells you what you want to do with it. So my advice is you talk to people about the plan, as many people as you can, but you don't tell them what the idea is, other than maybe you would tell them at a very broad level. Also, engage a good patent lawyer. That will make all the difference in the world for you. And I don't know how the university works with the patent writing and the patent lawyers there, but all this planning needs to be done. It doesn't mean you can't change your mind. Now, if you can't figure out where you want to file it, then find people who use or produce products like yours, find patents that they have, some of the larger companies, and find out and look up where they file them. That will tell you a lot about what they think is important, because if you're going to license it and sell it, where they want it filed is where you should be thinking about filing. The only exception to this is drug patents. They get filed in lots of places, and primarily I think it's for tax purposes and other things. But that's extremely broad filing. I had a client who in Australia who insisted for years we file in Vietnam. Now, I have nothing against Vietnam, but there's been, when I looked at it, there had been no patent infringement cases to my knowledge, and the damages were like limited to $20,000. You know, I don't see a lot of value in filing in a place where you're going to get weak protection or almost no protection. So, as I said, each country requires a slightly different writing strategy. So how you write the patent application before you file it, and even how you write the claims before you file it, is going to be different from country to country. You saw in the earlier talk how much the laws were slightly different in each country. You want to engage a patent attorney that has a sense of how it's going to work in different countries. They will have other firms in other countries that they work with, but you want to get as much planned out at the beginning as possible. The problem with this, and it's a big problem, is most patent lawyers are well trained to write a patent for their country or their jurisdiction. But that's not what clients want. What clients want is a patent that's going to work in China, it's going to work in the US, it's going to work in Europe, it's going to work in Australia, you know, or Japan. And all the rules are slightly different, or the processes are slightly different. So I just picked a few things out here. Some of this stuff may not really make sense, but if I'm writing a patent for Europe, US, China, and Japan, in the US with software and biotech, there's a statute called 101 that has to do with usefulness, but it's very broad and it's become a real problem. If you have software or biotech and you're going into the US and your lawyer doesn't know about what's called 35 USC 101, find another lawyer. The other thing with the US is all that prior art you've gathered, you have to disclose it. Probably one of the best things with the US is we have what's called continuation practice. They have it in Europe there, it's called divisional practice, and in China, but it's a slightly different set of rules. I don't know if they have it in Japan. A continuation practice means that once you filed your patent, and I'll stick with the US for this one, and it's been allowed and it's going to issue as a patent, you file the same thing again. It's called a continuation. And that's very important because if you issue the patent and it's locked, so you can't do anything more with it because you think you got the claims that you love, it's frozen. And once it's frozen, people like me can design around it or get very creative about how we design around it. In simple terms, if you have the continuation on file, then you can always go back, fix an issue with a prior art that comes up, write claims that are focused on third parties that are of interest to you, and so forth. I had a client in Switzerland that had an ultra high molecular weight polyethylene patent. And the deal we made with the person we licensed it to, as long as we had an issued claim anywhere in the world that covered the product they were making, they had to continue to pay us royalties. And there was millions of dollars worth of royalties flowing in. They 4 times redesigned the product to get over the claims we had. We went back to the pending case in the US, even though we had at that point 5 patents out of it. And we would just write new claims that read right on the product. We'd get them allowed, and they paid us until the patents expired, which was just recently. Okay, Europe, they have something, and I think they have it in China as well. But Europe, it's a big problem. It's called fair basis. And what it means is you have to show you had the entire inventive idea, which really means the claim, in one paragraph or one spot. And I can't tell you how many oppositions I've attended where we spend hours and hours and hours arguing over that before the European Patent Office. So if you're going to file in Europe, you want to think about that. You want to have a concept of fair basis. We don't have that concept in the US. In the US, we have rules, but I can take a sentence from one page, a sentence from another page, a word from another page, and put them all together in a claim. And as long as it's supported by the patent specification on file, I'll be able to get that allowed. So in Europe, it's expensive and they're very slow compared to other places. It takes a long time. I have a case recently for a client in Australia, and I think we're 12 years into it and we still haven't gotten anywhere with it, which is unusual. But basically the rules, how you write a patent for the US are different than how you write it for Europe. In China, which Chiang and I both have done a bunch of work, of litigation work in, I think the system's pretty good and it's getting better. But the thing I notice is if you're going into China, the more examples you put in of the way to use this thing, the better off you are, because they seem to like to go back to the examples and ignore some of the other text. At least that's just my personal experience. They also have innovation patents in China, which I think are a very useful strategic tool. And, you know, these are all different things that you have to pull together. Japan is one of my least favorite places to file. It's very expensive. I think probably the most expensive place to file. You get very narrow claims. You really only want to file there if it's for licensing purposes. This is just my opinion. I'm sure people from Japan would disagree with that. So to me, the most important thing at the beginning is how well the specification of the patent is written. All right. If it's well written, it's great. If it's poorly written, it's a disaster. And I've seen more patents fall apart on that than I could imagine. The one thing I would tell you is, yes, you want to get it on file as soon as possible, but don't file half-done provisional patent applications. They will cause you more problems than they're worth. You've got to get enough stuff together. So when we file provisionals for clients, they are, you know, 80, 90% done. You know, there might be a few things in there. The other thing people don't recognize is the patent is not about protecting your invention in a sense. You can practice your invention all you want. The patent is really about stopping others from designing around and taking the invention. So again, you want to write that in mind, because really what you want is you want to write it so a licensee or a buyer says, I can't get around this very easy. I need this, so I'm going to pay them for it. So flexibility, you know, we're not just talking about your invention. What you want to do is you want to write this and say, okay, how do I get around that? And if you come up with that, we put that into the specification. Drawings are very useful. The more of them you have, the better. Courts, especially in the United States, will hold statements against you quite a bit. So you have to be very careful. You have to appreciate a patent application is not a scientific document. It is a legal document. Every word matters. Every word matters. They're very difficult to write well. And they're very hard if they're very hard on you if they're not written well. And I've never understood this, because a patent over its life, if it's filed in 10 countries, is going to cost somebody $500,000 over the 20 years. If it's poorly written, you know, then it's not going to go very far. If it's well written, it might go further. So they're difficult to write. So get people who know what they're doing. As I said, we focus on a robust patent specification with a lot of variety in it. We try to cover as many alternative ways of doing something as possible. There's a case I worked on years ago, and it was over Pringles, the little potato chip. And they had the mold set up one way. It's been so long, I haven't thought about it. They had the mold set up one way. Somebody turned around and filed a patent where the molds went a different way, and they didn't have the alternative in their patent specification. And they were able to, somebody else was able to get a patent on it. So you want to build as much design around in as possible. And you want to maintain commercial flexibility by the patent continuation practice and the scope of the specification. As far as I'm personally concerned, from a commercial viewpoint, the day you issue a patent and you don't file a continuation in, I'll just say the United States for now, you've given up 80% or more of the value of what you filed. because I can design around a 50-word claim. I can't design as easily around a pending 50-page specification. The other thing is you want to put in functionality and advantages. You want to figure out what is actually, why is this better for people? What does it do? You know, and a lot of times that gets lost because nobody puts that type of functionality in. Now, functionality language can be tricky and you have to be careful with it, but ask, you know, I always ask the people when I'm working, I'm saying, what is this that this does better? I mean, why, when you go to sell it, what are you going to tell your clients, you know? So advantages and functionality are important. Again, these are just some things that we talk about. You use permissive words, no mandatory words. I just cringe when I see must or all in a patent. I had one I litigated for 7 years where somebody put the word all in and we lost ultimately, but it took a long time to get there. You take the main claim and you diagram it and you basically take some limitations out, put other ones in. You try to get as much variety as possible. You never say the word important or essential or critical. That will get you in a lot of trouble later on if the patent becomes important. We never use the word to preferred embodiment. Actually, we don't use the word invention in a patent application. But if you see the preferred embodiment, that's a mistake. It will get you in trouble. And you should have at least one figure that you think is as broad as your claim one. Okay, I don't know how much time I used. Patents, this is just a quick summary. Patents are really expensive to write well and maintain, but I think if you're gonna file them, you should do as good of a job as you can to get them written at the beginning. That is the foundation of everything. The specification that goes on file is the most important thing. In the end, the claims become much more important, but at the beginning, the specification. Many of them seem to end up with little commercial value. I've never done an analysis of that, but the ones that matter, when they matter, they matter. And you know, companies spend tens of millions of dollars litigating them. Do not overfile. Pick your countries and stick with them. Too many people want to file in 10, 15, 20 countries, and then they run out of money and they start cutting it back. You know, pick where you want and why you want to be there and stick with it. So I try to get people to file in lesser countries, not more. Use the patent cooperation process, which gives you 30 more months from your first filing to decide things. I think that's a good approach in many instances. And the biggest thing I would say is hire good people that know how to do this stuff and plan it and think about it. And that's all I have to say. Hello, Chiang?
Thank you, Mark.
Oh God, I thought I'd lost the audio. I thought I'd lost everybody. And I'd been talking to myself for 20 minutes.
Okay, can you see the screen now?
Yes.
Oh, good, thank goodness. Okay, and you can hear me well?
Yes.
Thank you. Okay. Thank you very much to Dr. He and Professor Lee for inviting us to this webinar. And really thank you so much to all the wonderful attendees. I know I have so much to learn from all of you and Dr. He and Professor Lee. So really thank you. Professor Lee asked Mr. Paulson and I to speak on the topic of global patent strategies and related regulatory issues and risks. Mr. Paulson spoke on global patent strategies, and then I will cover the related regulatory issues. Professor Lee asked Mr. Paulson and I to give inputs from a practical perspective based on our working as practicing lawyers. I spent half of my time on patent and trade secret lawsuits in China, and I spent the other half of my time on working on intellectual property aspects in mergers and acquisitions and on public listing like IPOs. And Dr. He, who unfortunately cannot join us today, was going to cover the topic of why you should patent your invention, why you should protect your invention. Unfortunately, he cannot make the presentation today. From my patent and trade secret litigation perspective, it is much more difficult to protect trade secrets. Mark mentioned that, if you can protect your invention through trade secrets, that's great. But most of the time you cannot. So it is important for you to try to patent your invention. Today I won't go into patent and trade secret litigation, but I just wanted to share my thoughts on the importance of patenting your invention since we don't have the benefit of Dr. He's presentation today. And today I will cover some key regulatory issues relating to global patenting strategies. The issues are listed here. I hope that not all of them are new to you because they are relevant to global patenting strategies. And we should always keep these issues in mind in protecting and commercializing your inventions and creations. Now, these issues here are under mainland Chinese law. I understand that you are dealing more and more with the mainland, and hence they are relevant. Moreover, when you license and commercialize your invention in other countries, you should find out if there are similar regulatory restrictions. So I'll just dive in one by one into these issues. You should be familiar with China's technology export regime, and a lot of countries have similar regulatory regimes. Technology export is basically licensing or assignment of technology or provision of technical services by a Chinese party to a non-Chinese party. So cross-border licensing or assignment. China divides technologies into three categories. They are prohibited technology, restricted technology, and unrestricted technology. So prohibited technology is technology that you cannot assign or license or transfer outside China. Restricted technology is technology that you can transfer outside China if the Chinese government gives approval. And unrestricted technology is technology that you can transfer outside China if you record it with the Chinese government. So you let the government know. And the different technologies in the different categories is set out in this link, and they are updated periodically. I'm not sure if you, I think you should be quite familiar with the latest update of the list because it just happened during the TikTok scenario, the TikTok saga. Basically, the Chinese government categorized TikTok's technology into a restricted technology, which during the process, during the process where the US government wanted to ban TikTok or force TikTok or ByteDance to sell the US business of TikTok. So basically what the change in the law resulted in is that because the because the government categorized TikTok's technology into restricted technology. So that means that TikTok cannot sell or license the technology, say to a US company, unless the Chinese government gives approval. But most of the technologies we work with are actually unrestricted technology. And there, all you have to do is tell the government by a recordal process, then you can enter into licensing or assignment agreements with parties. And if you are involved in a restricted technology, then you need to get the license from the government before you can enter into cross-border licensing or assignment. And when you submit the application to get the license approval, is the Chinese Ministry of Commerce and the Chinese Ministry of Science and Technology that will be looking at your application. The law says that it would take about 45 working days for the approval, but in practice, it takes much longer. And according to the law, you're not supposed to negotiate until you get the initial approval from the government. But in practice, a lot of people don't know about this regime and do enter into negotiations before they get the initial approval. And under the law, the validity, effectiveness, and enforceability of the licensing or assignment contract are affected if there's no government approval. And one more thing I want to mention about this regulatory regime is that there is criminal liability aside from other liabilities if you violate the requirements. These are the criteria that the Ministry of Commerce and the Ministry of Science and Technology will look at when they approve your application. As you can see, these are very general criteria. So there is a lot of discretion involved in the approval process. You're welcome to have a copy of this PowerPoint document. I think Hong Kong U has it, so otherwise I'll be very happy to provide copies to you. So I won't go through these criteria in detail now. But you get the sense of it. Like, for example, number 3, whether the export endangers national security. And the first one, whether the export is in line with China's foreign trade policy. I'll go into the next issue, which is technology import. So here involves the licensing or assignment of technology, whether it's medical technology, electronic technology, IT technology, from outside China to inside China. So for example, if you are licensing a Chinese university, some technology that you have, then you would fall within this regulatory regime. Because under the law, Hong Kong is considered a cross-border when it transfers technology into China. Again, the technologies are divided into 3 categories, just like technology export. And this link sets out the current list of prohibited technology, restricted technology, and unrestricted technology. And the list is updated periodically. Again, there are criminal liabilities aside from other liabilities. if this regulation is not complied with. So again, just like with the technology export regime, if you are dealing with a restricted technology, then you need to get government approval before you can even license the Chinese university to use your technology. Okay, I'll go into the third regulatory regime that you should be aware of. This is the state asset regulatory regime. And I will talk about two main aspects. First, I'll talk about the state-owned companies and institutions' assets, and then I will talk about private companies or institutions who gets research grants. So on the first topic, which is assets of the state-owned companies and institutions, I think is quite straightforward that you understand that you know, the state-owned companies or institutions assets are state assets, and if let's say let's say the Chinese Science Academy wants to license its patent to you for use, then it needs to get Chinese government approval. So and so any disposal of state assets needs government approval. And disposal includes assignment and licensing. And one thing to note is that under Chinese law and maybe other laws, there are differences between exclusive license and sole license. Under Chinese law, an exclusive license precludes even the licensor from using the licensed subject matter. So let's say a university grants a sole license to a company, then the university can still use the technology. But if the university grants an exclusive license to the company, then even the university itself cannot continue to use the technology. So you need to keep this in mind. The next topic relates to research funding. So even if, let's say, a private company, but if they get research funding, let's say from the government, then you need to look into the issue of state asset disposal. So under the Chinese Enterprise State Asset Law, rights formed by contribution by the state is also considered state asset. Now the legal provision is quite vague, and they do not say, you know, the proportion of contribution needed to render the created property as state asset. So they do not say that, well, you know, does the state need to contribute 50% of the cost in the R&D of this patent or technology before the patent or the technology would be considered state asset. And also the form of contribution is not specified. So there are issues on whether technology or patent generated from the use of government grants would fall within the definition of state asset. To take one example, in the Shanghai Municipal Science and Technology Regulation, it states that if state funding is provided for a project, in case of state benefit or important social public benefit is concerned, the intellectual property rights generated from the project would vest in the state. Although the party receiving the government funding would have the use right, and the party does not need to pay. So you need to be aware of this issue, and you do need to look at both national and local legislation on whether that they will be relevant to govern the project that you're working on. So oftentimes, you are probably aware that local regulations of Science and Technology Bureau, they will require that if they provided research grants for a project, then the company or the university would have some obligations, for example, to provide public education on the technology or the project, and or maybe keeping the government informed of the project. And on the issue of public education, it's important that you discuss with the government authorities to make sure that these public education efforts are not carried out until after your rights are protected. Like, for example, you have filed a patent and things like that. And also, if let's say you receive a research grant and that was used on your project, and the project resulted in some kind of invention and that was patented, or you have filed a patent, and now you are thinking about commercializing that invention by licensing to third parties. Oftentimes, the licensing or the commercialization, the other party would require you to keep confidential a lot of information. So again, these are the sort of things you need to talk with the government authorities to make sure that you do not violate these confidential obligations while balancing what you need to do under the research grant. The next regulatory regime I want to touch on is the state secret technology regime. State secret technology is defined as technology set out in a list, published, but is circulated within a small circle. So whether the technology involved is a state secret technology may not be a public information that it may not be publicly accessible. So there's a lot of uncertainties, and civilian technology may be considered state secret technology as well. And then the requirement is that if you want to license or assign a state secret technology, let's say cross-border licensing or assignment, then of course you need to get state approval. I mentioned about the definition of state secret technology, and and there being a lot of uncertainties on whether what you're holding is state secret technology. I have once seen a state secret technology certificate, and that it was a deal. The Chinese party who owns the technology was issued that certificate, and the product was a medicinal product uh, traditionally used for cardiac um, uh, diseases. But then there was a new discovery that the product can be used to um, control weight gain. And, um, and the Chinese company want to license the technology to a US company, a US life sciences multinational. Um, and, uh, and then during the due diligence, we found the state secret technology certificate for this product. Um, but um, it is currently unclear whether all state secret technology are issued such certificates. I suspect that not all of them are issued the certificates. So how do you know? Uh, I think if you have some suspicions, you should talk to the Ministry of Science and Technology and the Secrecy Bureau. So you need to make some informal inquiries, besides formal inquiries, to avoid, um, uh, violating the law. The next regulatory regime I want to touch on relates to health big data. Health big data is defined as data relating to healthcare generated in the process of human disease prevention, treatment, or health management. Um, it's a very wide definition, um, and it seems that it covers all data. And seems like, if you have data from a patient record, it can be considered health big data according to the definition. Um, so there is, again, a lot of uncertainties. And under the law, if you are having a cross-border transfer of these data, it is prohibited unless you proceed with security assessment. But currently, these assessment criteria and process are not very clear. The next regulatory regime that I'm going to talk about is the Human Genetic Resources Regulatory Regime. I'm sure a lot of you are quite familiar with this regulatory regime. Human genetic resources is defined as organs, tissues, cells, or other human genetic resources. And the definition also includes information. So let's say you are conducting clinical trials in China, and you need to transfer the information to Hong Kong. Then you need to get the government approval before you do that, because even the information, even if you're not transferring the specimens to Hong Kong, even if you're just transferring the information on the specimens to Hong Kong, you need the government approval. And the regulator, which is the HGRO, Human Genetic Resource Administration Office, it has been very active in enforcing the regulation, and punishment decisions have been issued, and they have been issued against AstraZeneca, as well as Oxford University of the UK. And the decisions are publicized, and there are also risks that the regulator would blacklist the offenders. So, for example, if you conduct clinical trials in China and you did not get the approval, you can be blacklisted, so that you won't get approval for, in future for a number of years. And another thing with the approval process is that, when you submit the application to the government authority for approval, the regulator may require you to change the structure of IP ownership, even though the structure was already agreed to by the parties. So that you need to keep in mind. And basically, the regulator wants to make sure that the Chinese party involved is not disadvantaged, or that they want to make sure that there will be a level playing field between the parties. I think this is the last regulatory regime I'm going to talk about. Again, I think that you're quite familiar with this regulatory regime in relation to improvements. Is in the Chinese contract law that has been in existence for many number of years. Basically, the employee inventors have statutory guarantee to a portion of the income generated from the licensing or assignment by the employers. Professor Lee mentioned that, oftentimes it's the employer that will own the invention, and that's common in many countries. And Chinese law requires that when the employer licenses or assigns the invention, the employee would get a portion of the income. And of course, Chinese law also requires the employers to give awards to inventors for the invention. Another thing is, the requirement of the law is that the employee inventors have the right of first refusal in case the employers are to license or transfer the invention. So what that means is that, so let's say the employer wants to license to, let's say, HKU to use the invention. The employer in China needs to give the right of first refusal to the employee inventor to license at the same terms. You can see sometimes competitors can misuse this legal right. So, for example, they can collude with the employee inventor to preempt the license or the transfer by the employer to someone else. So these are the kind of issues you need to keep in mind when you commercialize or license your invention. So thank you very much again. I hope you have questions for us.
Here comes to the Q&A section. Audience, you can feel free to raise all your questions. Okay. And we found that there's a couple of questions in the Q&A chat box. So Dr. Lee, Mr. Paulson, and Ms. Lee, you can choose to answer through by clicking the answer live.
I see there's a question here. It said that if I have a patent file in China, is it valid in Hong Kong? And may I use it to sue somebody for infringement in Hong Kong? Unfortunately, the answer is no. Patent is territorial, so a Chinese patent is not automatically enforceable in Hong Kong. So what you need to do is when you file the patent in China, you need to let the Hong Kong IPD know and record it in time. And then when the patent in China is granted or published, you also let Hong Kong IPD know. And then you can also get a Hong Kong patent. Then in that case, then you can enforce the Hong Kong patent in Hong Kong. Now, one thing to know is that I think Professor Lee and Mr. Paulson, please chime in. A lot of times when you file patents around the world, the deadlines often can be extended. But please know that in Hong Kong, the deadlines cannot be extended. Okay, so if you miss the deadline, you lose your rights. There are no possibility of extension. So when you file the patent in China, then you need to inform Hong Kong IPD. It's called a recordal process. Okay, and also you then need to later on again inform Hong Kong IPD about the progress of the patent filing when it's published, granted, whatever, in order to not lose your rights to the Hong Kong patent. I wonder if there's a follow-up question from Eddie on the response.
And I think I would like to answer Mr. or Ms. Wai N's follow-up question on the Hong Kong short-term patent. And his question is the short-term patent system allows two independent claims as opposed to just one. You know, what this means and its implication. I think this it's a good change. It's allowed to permit a second independent claim, and this should enable applicants to obtain more than one species of claim. For example, like a product claim and a method claim. And this will basically enable the broader short-term patent protection. So it's more, and also it's a more cost-effective than before. Yeah, this is my answer. I don't know if I answered this question. Another question is about if I have a patent file in China. It's I think this has been answered.
Yeah.
Yeah.
It's Mr. Ng's question for PLLC. Will you file utility model patent and invention at the same time? uh, yeah, a lot of times you do that, and then and the reason is you can get a utility model patent much sooner because there's no substantive examination. And then because there's a rule against double patenting, so what happens is once you get the invention patent, then you withdraw the utility model patent. However, there are exceptions. For example, if the claims are not the same in both patents, then you may continue to keep both patents.
Yeah, I would like to add that it's actually recommended to file both utility patent and invention patent at the same time because as the Chiang said, the utility patent could be obtained earlier and easier. So when you get the utility patent, you basically get the early protection before you get the invention patent. So and then when you get the invention patent, you can drop the utility patent. So you you basically get a earlier protection than just filing the invention patent.
Yeah, it's like you get the cake, the piece of cake, and you get to eat it too.
Mm-hmm. Another question is about from your practical experience, is there an invention in Hong Kong? Where would your first destination of filing? I think it is still suggested to file U.S. patent provisional first. And I think that's because U.S. provisional is easier and faster to claim the priority, and then you should consider to file Hong Kong patent. And normally we also file China and China and the U.S. depending on how important your invention is. And about the, is there any international application that covers all country? Procedurally, you can file PCT, Patent Cooperation Treaty, that will allow you file first, and then later on you decide which country you want to cover, and then transfer to national patents, and then but that. And substantively, there's no such international patent covering all country. And as the Chiang mentioned earlier, IP is territorial, and the patent right is also territorial. And there's only national patent, not international patent. Okay, so unfortunately, right now we don't have that. If you want to get protection in any specific country, you need to file the patent application in that specific country. But procedurally, as I said, the PCT provide the advantage that you can file PCT patent first, and then if you decide which country later on, within about 1 year, if you decide which country you want to file, and then that will transfer to national patent. Then you can PCT patent will do some the preliminary search and evaluation of your patentability for you. Okay. Any other? Mark, do you like to answer some question?
Yeah, like the one, what are the criteria for an application to be granted?
Well, in general, hold on. In general terms, it's basically, it has to be novel, the claim has to be novel, and it has to be, it's called different things in different countries. We call it not obvious. The novelty is pretty easy to establish. The not obvious is very difficult to know exactly what that means, but it's basically, in the US, it's not obvious to one of ordinary skill in the art. It's a little bit more nebulous, but they're pretty easily overcome when you talk with the patent examiners in the different offices. Somebody also asked, with the PCT is just a holding thing. You get a search report, but there's no prosecution. And you also want to be careful, because there are certain countries, like countries in the Mideast and Taiwan, that are not covered by the PCT. So if you're going to file in those places, you have to do it, 1 year from when you first filed the provisional, and you have to file there directly. And there's, I think Venezuela may be another one, but that's something you have to be aware of. But the PCT does not involve prosecution. It just gives you more time. It's basically around 30 months from your first filing. You file the PCT at the 1 year mark, and then you can wait for the rest of the time to decide what countries you want to go into national stage filings for. What is this? So it's something, the patent prosecution highway is a useful system. I don't use it very much because I'm not ever really interested in, for the most part, in getting an early patent. What I really want is to get a good specification on file. But it's, if you use it, what it does is, if you go to a country like Australia and you get it allowed, you can then submit that record to the US, and they're supposed to treat it with more deference. So a lot of people like using it. I've never used it, to be honest with you. It just, because that's not what the patents are really about. Until you tell me you really need the patent and what you want to use it for, then I'm less interested in getting it allowed. I'm just as happy for it to be sitting there as a pending specification. Now, that doesn't work with some startups, because some startups need to raise money. So if that's the case, and having an early issued patent, will go to the US, probably file it, get it allowed as soon as we can, and there's ways you can accelerate that process in the US. So now they have the piece of paper that seems to make people comfortable that we have an issued patent. It's not something that I normally do, but we will do it if you need it for raising money or convincing a potential licensee that you're going to be able to protect it.
There's a question on the on how to preempt the competitor from abusing the employee inventor's right of first refusal. Well, we lawyers do a lot of things to try to preempt that. So for example, agreements with the employee, and structuring the relationship with the employee inventor, in a creative way. The problem is, it is questionable whether any of those methods will actually work, because the court may take the position that the provision is something that the parties cannot, the employer and the employees cannot contract out. And there hasn't, as far as I know, there hasn't been a court case on this issue. So in the meantime, we continue to structure transactions in different ways. So for example, um, we would structure the R&D as a commissioning arrangement where the employee inventor is the commissioned party, because under the law, the commissioning party can enjoy all of the rights from the creation or invention. And there hasn't been a court decision ruling that such a methodology is not workable. So yeah, this is a very interesting question. The legal provision has been there for a long time, but we haven't seen a court case on this provision.
There's a question in here. Does a patent application, since it doesn't require all the inventors to sign, can somebody then be falsely named as an inventor without his or her consent for a patent? I don't know about in the PRC, but in the US, when you file the national phase, you do have to sign declarations, and all the inventors have to sign. Unless one refuses, and then there's a special process you can go through to show that there's already been an assignment to or somebody else has the power to do it. But in the US, if you name somebody who's not an inventor or falsely name somebody, you're going to take a great risk that the patent, if it were ever disputed, would be held unenforceable. So that's not something that is going to happen if there is a patent attorney involved in it as a general rule.
I think in China, I think if anyone be falsely named as the inventor without her or his consent, then that I think need to be, as I mentioned in my presentation, then the other inventors may request for the mediation or litigation to solve the problem. And I see the question about if I invent a teaching product as a teaching material and won an international innovation award, and then use the product to apply for university funding for educational research, that the patent belong to the university. This question, the answer really depends on whether you are staff or students, or whether you, if you have signed the contract, employment contract, and then you are staff, and if you invent the teaching material during the course of your employment, performing your normal duty of the, as the staff, or you use the university material, substantially, not incidentally, and then your invention it belongs to the university, and then. However, if you are staff but you invent the teaching material completely outside your teaching duty, because if you are teaching and you invent the teaching material for your teaching purpose, actually, I think that might be considered as a normal, in the course of your normal employment. But if you are students, and you didn't really use much of the university material or funding or equipment, whatever. You just invented completely outside and for your own enjoyment or whatever, and then you get the innovation award. And then that might be considered as your own property. So it's really depends on, but I think in most of the situation, if you invent something during the course of your normal employment, and then that will be considered as the university IP.
We are a bit overrun today. Do you have any more questions? Okay, if there is no more questions, maybe we can finish the webinar here. Thank you very much. Thank you, Dr. Yahong Lee. Thank you, Mr. Mark Paulson and Ms. Charlie Lee, to share the professional knowledge and insight with us. This is really a very fruitful sharing section. And thank you very much for participating in the webinar. TTO is hosting a series of webinars, so stay tuned with us.
Well, thank you very much, particularly to the attendees. The questions were wonderful. And thank you to Professor Lee, and thank you to Mr. Mark Paulson.
Yeah, I would also like to thank Joanne and Emily for organizing and for putting up everything, the poster and the promotion, everything. And I also like to thank Chiang and Mark for being willing to participate, and particularly Mark. And I think right now it's almost midnight.
Yes,
see,
but
right?
but I like Hong Kong time because it's always 12 hours opposite. It's easy to remember.
Okay. Yeah,
I miss going there.
Yeah, and come as early as possible.
Thank you, all of you. Thank you. Thank you, Joanne.
Thank you very much. Thank you. Bye-bye.
Bye.